All right, Patty, that's all signed up.
Hey, Judge.
All right. At this time, the court calls case number 646-286, State of Texas versus Julia Ruthie Hernandez. Attorney is James Hunt. What is the purpose of this hearing?
Your Honor, I scheduled it based on the defendant's request to have a special hearing regarding her issues with the court-appointed attorney, James Hunt.
All right. Ms. Hunt,
I'm present, Your Honor.
thank you. Mr. Hunt, pardon me. Ms. Hernandez,
Yes, Your Honor.
it's this hearing or motion or whatever it is that your request. You're up. You're on the floor. Tell me what's going on.
Yesterday I talked with Mr. Hunt and the conversation did not go well. So I guess I would like to get a new court-appointed attorney.
Okay. I need more than the conversation did not go well. What are you talking about?
He was very hostile and rude to me, Your Honor, and was addressing me in a threatening manner to file for a motion of withdrawal, and along with his withdrawal said that he was going to inform the judge of something that he wouldn't like to hear. But I've never been rude to Mr. Hunt, so there's nothing that he could say. So I just took it as if he was going to make my case harder for me to deal with. And I was very emotionally distraught after our phone call yesterday.
Mr. Hunt, regardless of what the conversation was, do you believe it's in the best interest of justice that you withdraw?
Well, Your Honor, actually, we're to the point where we've applied for pretrial diversion. Is there a representative from the state available?
Yes, sir.
I'm here, Judge.
Her pretrial diversion was rejected because I believe the state didn't have their recommendation in there, but I believe we discussed that and the recommendation should have been in the file.
What's the case number?
It is
646-286.
Judge, I don't have any notes, at least in my system, about an application for PTD. I could check the physical file, but you'd have to give me a second. I'd have to pull it from the shelf.
Judge, I'm fine with withdrawing. The defendant wanted a copy of her file, which would include, her file essentially consists of what the DA's file is, and I can't provide that as my agreement with the DA's office is for discovery. So I said I would not do that.
All right.
And that could impact my other clients' opportunities for discovery. And this is a pretrial diversion case. She requested pretrial diversion. I believe the agreement was that the state would recommend it. And her application was filed along with 3 or 4 other clients at that time. So I can't provide the correspondence because that would relinquish other defendants' names and information. So a copy of the file is not going to be provided to defendant.
Ms. Hernandez,
Yes, Your Honor.
would you be satisfied if at the end of this matter, you get a pretrial diversion? Are you aware of what that is?
Yes, Your Honor. I just have not been receiving updates on my case or been able to ask questions to Mr. Hunt without getting hostile replies. So I'm not too familiar with the process or aware of what's going on due to the fact that I just have not been properly informed. He would not tell me what my next court date was or what would be happening as far as the pretrial diversion. I have not received updates on that or any paperwork that was filed.
And that would be because she has not been accepted to pretrial diversion yet.
All right.
Yes, Judge, that would suffice.
Mr. Hunt, I'm going to ask you to finish this pretrial diversion application. I think you've already made the application. I want you to finish this matter. I would caution you to be extra careful with your defendant. As you know, she's upset with you, rightly or wrongly. I'm not judging that at this point. I don't want to be forced to do that either. I'm not going to go into a lengthy discussion of what's going on. So I'm going to recall this in 1 week.
Judge, actually, could I hold on? I believe Ms. Pollard is looking to see if the physical file has anything in it.
All right.
I can hold tight. I believe you might have a plea or something on your docket this afternoon.
We do. I've got a couple of them, not just one. All right. Then Ms. Hernandez, if you'd do me a courtesy and just wait. You can mute yourself and relax. I'll come back to you shortly. I've got 2 other cases to take care of right now, and we'll do that. And we'll come back and try and resolve this matter satisfactorily. Okay?
Okay, Your Honor. Yes.
All right. Now we have Ivan Pina and Marcus Smith. Are we ready on Marcus Smith now? I'd signed everything. And I know I've signed everything on the Pina.
Yes, Your Honor.
Mr. Acevedo? Albert Acevedo? You're not frozen, are you? Move around. Okay. I don't hear you though. You're not muted, but I don't hear you. Speak up.
I'm here, Judge.
Thank you, Ms. McGinnis.
Hi, Judge. How are you? Sorry, I
I'm well.
think you called my name, but I was.
Mr. Acevedo,
Yes, sir, Judge. Can
I can hear you now. Try it again.
you hear me now?
Yes, sir. All right. At this time, the court calls
Sorry
case
about that.
the court calls cases number 581216, State versus Marcus Smith, and 571199, State versus Ivan Pena. I'm sorry. Miss, is it Ms. Ivan Pena?
Yvonne Pena.
Yvonne,
Alright.
Judge. She
Sorry about
pronounces it
that.
Yvonne. Yes.
All right, and we have Mr. Marcus Smith.
Yes, sir.
All right,
Yes, sir.
Mr. Smith and Ms. Pena, would you please raise your right hands? Do each of you solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth? Ms. Pena,
Yes, Your Honor.
thank you. You may put your hand down. Mr. Smith,
Yes, Your Honor.
thank you. You may put your hand down. Now, each of you has your own allegations, and it's my understanding that you each have decided to enter a plea. Before we do that, I have to make clear to you verbally and on the record by my court reporter, Ms. Kayleen Rivera, that you have certain rights and protections. First one being the right to remain silent. That means you each individually have the right that you cannot be compelled to make any statement. You cannot be compelled to answer questions, and you are not required to submit written paperwork that has your signature, especially papers that admit or confess to wrongdoing. Do you understand you have that right, Mr. Smith?
Yes, sir. Yes, Your
Ms.
Honor.
Pena?
Yes, Your Honor.
In addition, you have the right, each of you has the individual right to a jury trial. That means that each of you, with your attorney, could select, with the participation of the state, 6 individuals from a jury pool, disinterested citizens that would hear the entire trial, and each jury decide whether you have been, whether you're not guilty or whether you have been proven guilty beyond reasonable doubt. That's the right to a jury trial. You understand you have that right, Ms. Pena?
Yes, Your Honor.
Mr. Smith?
Yes, Your Honor.
You also have the right to confront witnesses. If you were to go to trial, the state would be required to submit witnesses who would testify. You in turn would have the right, with your attorney's assistance, to question, cross-examine, or challenge any witness who testified. That's basically called the right to confront witnesses. You understand you have that right, Mr. Smith?
Yes, Your Honor.
Ms. Pena?
Yes, Your Honor.
You also have the right to appeal. Once this matter is concluded and resolved as far as punishment, whatever, each of you has what's called the right to appeal. That's done by you individually or with the assistance of your attorney, or your attorney does it by himself or herself. That right is a technical right that includes requirements, technical requirements, I should say, is a better word, a better way to describe it. It has time limitations. It has form and substance requirements as far as how you do it and what kind of forms are required. You could demand that a higher court review the official record and for whatever legal challenges you wanted to make. That's basically called the right to appeal. You understand you have that right, Ms. Pena?
Yes, Your Honor.
Mr. Smith?
Yes, Your Honor.
And finally, you each have the right, and by the way, the state does also individually, you each have the right to demand that this proceeding be held in the open public courtroom. Because of the COVID pandemic, we're not doing that. We're about to change over, but that still doesn't change the fact that in your case, we're doing it only with your consent. We're doing this by video conference. Do you understand that it's with your consent only? Mr. Smith?
Yes, Your Honor.
Ms. Pena?
Yes, Your Honor.
All right. Now, Each of you has reviewed documents and signed them. Did each of you review the documents that have your signature and that are part of this proceeding? Did you each review them carefully with the assistance and counsel of your attorney? Ms. Pina,
Yes, Your Honor.
Mr. Smith.
Yes, Your Honor.
Among those documents, the first one I'll ask you about is the one that says that you consent to video conference. Is that true that you reviewed that document and you have signed the document consenting to video conference? Mr. Smith,
Yes, Your Honor.
Ms. Pina,
Yes, Your Honor.
attorneys, Mr. Acevedo and Ms. McGinnis, did you each carefully review the documents that your respective clients have signed as part of this proceeding? And are you satisfied that they knew what they were doing? Ms. McGinnis,
Yes, Your Honor.
Mr. Acevedo.
Yes, Your Honor.
All right. In addition, did each of you attorneys sign an affirmation that declares that the state has complied with Article 39.14 Texas Code of Criminal Procedure in that they have fully given you discovery upon which to base your counsel and your decisions with your client? Mr. Acevedo,
Yes, Your Honor.
Ms. McGinnis.
Yes, Your Honor.
All right, now, Ms. Pina and Mr. Smith, there's a very important document that each of you has signed. It is called Defendant's Waiver of Constitutional Rights in Courts Admonitions. This document, besides identifying you, says what you're charged with, that you're pleading on, how you're pleading. It explains to you what the range of punishment is for the offense that you have allegedly committed or that's involved here. And it has a section in there that has 15 numbered explanations or counsel that it tells you, among other things, the range of punishment. It tells you the different rights and protections that we have discussed verbally. It reminds you in writing, including the right to a jury trial, the right to confront witnesses. It even includes that the deal that each of you has made with the state is not binding on me as a judge. As the judge, I have to say yes or no to your deal, to your plea agreement. It is my authority and responsibility. If I refuse your deal, if I reject it, or if I give you a punishment, which I have the authority to do within the range of punishment for your case, but it is greater than what you agreed to, in either of the two cases, then the law would allow you to start all over again, and you would not, what you signed and said up till now would not be used against you. Is that clear to you, Mr. Smith?
Yes, Your Honor.
Ms. Pina?
Yes, Your Honor.
All right. Now, tell me, state and defense, are these going to be probation or anything other than probation?
Ours is probation, Judge.
Probation on both?
No, Mr. Smith, Your Honor, it's a time served.
I'm sorry?
For Mr. Smith, it's a time served offer.
Jay said,
Yes, Your Honor.
all right. And on Ms. Pina, it is going to be probation,
Yes, that's correct, Judge.
not a deferred.
Not a deferred.
All right. Ms. Pina, before you enter a plea, I need to basically review this with you. Did you read over with your attorney the document that explains what probation is?
Yes, Your Honor.
Did you not understand what you signed by signing that application?
I understood.
Just to remind you briefly, probation is a written legal binding, a written agreement between you and this court. That agreement is that you will be entering a plea. There will be a punishment, including jail. but that jail portion will be suspended and probated so long as you live up to the conditions of supervision, which will be read to you and explained to you by probation office. You understand that's basically what probation is about. You'll be supervised outside of jail.
I understand, Your Honor.
If you violate the conditions, either you fail to do them or you refuse to do them, the state may ask me to give you official notice, bring you in for a hearing, and if the evidence supports it, revoke your probation, the suspension, and put you in jail. That's a consequence that's possible. Do you understand that?
I do understand. Yes.
All right. Now, Mr. Smith,
Yes, sir.
you've been charged with the offense of theft. To that charge, what is your plea, sir?
No contest.
A no contest plea in this court is taken as a guilty plea. Do you understand that?
Yes, sir.
Did anyone threaten you, intimidate you, or promise you anything other than the plea agreement in exchange for your plea of no contest?
Did anyone? No, sir. No, Your Honor.
All right. I accept your plea of no contest. Based on your plea and the evidence, I find you guilty. State whether the particulars of the sentence.
Your Honor, it's going to be 180 days in Bear County Jail, credit for time served, a $2,000 fine, time and money to run concurrent, and we would request that the judgment be satisfied.
Mr. Smith, is that your understanding of the agreement?
Yes, Your Honor.
Mr. Acevedo, is that your understanding of the agreement? You're muted.
It is, Your Honor.
All right. Then I find you guilty, as I announced a moment ago, Mr. Smith. You are fined $2,000 plus court costs. You are sentenced to 180 days Bear County Jail. Credit for time served, time and money run concurrent. The state finds that you have satisfied this judgment. And on this case, you owe nothing further to the state of Texas or this court. Do you have any questions, Mr. Smith?
No, Your Honor.
Any questions, Mr. Acevedo?
No, Your Honor.
Any questions from the state?
No, Your Honor.
All right. Mr. Smith, you're ordered to go by the offices of County Court at Law Number 5 within 7 days. During that time, you to have your thumbprint placed on the documents as required by law. Is that clear?
Yes, sir. In the next 7 days?
Within the next 7 days. That means you go today or within 7 days, but you must go in and have your thumbprint put on the documents.
Okay, yes, sir.
Ms. Pina, in your case, you have a charge of DWI with extreme intoxication. State, do you have any motions?
Yes, Your Honor. At this time, the state moves to abandon the extreme intoxication enhancement and proceed on a DWI first.
No objections.
There being no objection, the court approves the motion. Ms. Pena, you're now charged solely with DWI first, which is a Class B misdemeanor. That means that you're punishable by a fine of $0 to $2,000 and jail from a minimum 72 hours to 180 days. Do you understand that?
Yes, Your Honor.
The motion having been granted, now we're proceeding on DWI first. To that charge, ma'am, how do you plead?
No contest.
A no contest plea, as I have said a moment ago, is considered a guilty plea by this court and is sufficient for me to convict you of that charge. Do you understand that?
Yes, Your Honor.
All right. Now, state what is the agreement in regards to the punishment?
Your Honor, it would be 180 days probated for 12 months, a $600 fine plus court costs, 48 hours of community service, DWI education course, victim impact panel, a TAP evaluation and follow recommendations, ignition interlock for half the term, and a $50 Crime Stoppers fee.
$50 what?
Crime Stoppers fee.
Crime Stopper. Ms. Pena, how do you support yourself? How do you make a living?
I currently am not working. I'm on unemployment. I got sick with COVID, working at a nursing home, and I've been sick ever since. So
And what?
I've been sick. I had got diagnosed with long COVID, so I get unemployment.
All right.
And Judge, I can explain if you wanted some more information about that. I planned on asking for the supervisory fees to be lowered just because of this. She explained to me earlier that because she has been diagnosed with this, it has reoccurring symptoms, and she was diagnosed in December of 2020, but got symptoms again in March of 2021, which made her have to leave her job. That's why she was on unemployment for a while. She's starting a new job next week, which is why we asked to do the plea early so that she could get over to probation and do whatever she needed to do. But because she's kind of a little bit behind and it's been a struggle, we're asking if the supervisory fees could be lowered.
Where will you be working and what will you be doing?
I'll be doing case management for Oscar Health Insurance. It's a company, and I just help seniors connect with resources and
And
it's
what will be your income?
I think it was maybe 60,000. I think it was that they were trying to offer me.
Okay. Ms. McGinnis, ordinarily I'd be very sympathetic, but with that kind of income, do you have children you support?
No, not currently.
Okay, no, we're not going to do that. Good try, Kelly. All right. I accept your plea of no contest. I assess a fine of $800, which is greater than what you agreed to, which gives you the opportunity, if you choose, to start all over again. You are sentenced to 180 days, Bexar County Jail, suspended and probated for 12 months. You will perform 48 hours of community service restitution. You will complete the DWI education program in good faith, the victim impact panel. You will submit to a TAP evaluation and the recommendations. There will be a $50 one-time donation to the Crime Stoppers. You will have ignition interlock installed in your vehicle for 1/2 the term, which at this point is the minimum of 6 months. There'll be a continuous 6 months, and you're not to drive during those 6 months. You're not to drive any other vehicle other than your own with the ignition interlock installed. Your supervisory fee will be $52 a month. If for any reason, Ms. McGinnis, it turns out that she is not able to accept the employment, although it sounds like she has, would you file a motion for reconsideration?
Thank you, Judge. Would the court consider probating a portion of the fine, at least the extra 200? Just, we wouldn't withdraw the plea, but if that was the case, that would at least help her get back onto her feet, because I know I don't want her to be punished for being proactive and trying to get off unemployment. She did hire us back in 2018 when she had more stable employment before she was getting sick. So I don't know. I know she's got a lot of health issues that are ongoing that she's dealing with. So I don't know if you would consider, we'll accept the other extra 200, but would the court consider probating it? She's been on bond for 3 years with 0 issues. She doesn't
I
even,
appreciate that, but with a $60,000 income, there's people that make half of that and wind up getting $500 or $600 fines. I would not consider that. I would not do that acting in good faith. I think it's appropriate under the circumstances. Ms. Pina, I hope that you do well. I have one young man that's a good friend of my son who has had COVID 3 times now. And I hope you're not among those who gets it a 3rd time. It is very unusual for a 2nd case, much less a 3rd one. So stay well, be safe.
Thank you.
Any questions, Ms. Pina?
No, not at this time, Your Honor.
All right. You'll have the whole year to pay that, by the way. You understand that? Any questions, Ms. McGinnis, other than those that you voiced?
no, Your Honor.
All right, state any questions.
No, Your Honor.
All right, then y'all are, wait,